Good evening, everyone. Advocate on Record Aspirants Academy welcomes you to our free lecture series, lecture number 28. Today is a historical day, a red letter day in AOR Aspirants Academy for the simple reason that we are going to felicitate and celebrate the success of our Advocate on Records in the AOR examination 2024. We are going to felicitate all AORs for two purposes. So before that, I'll be dealing with the topic, but it is our regular practice. It is our regular practice that we strongly believe that preamble our unity and preamble our identity. So we recite preamble as our daily prayer. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now let me address about our topic today. Who is an amicus curiae? First and foremost, I must tell you why we have chosen this topic. The reason is, it is one of the frequently asked questions in the AOR examination, which comes under part 3, that is advocacy and professional ethics. So who is an amicus curiae? What are the duties and responsibilities of an amicus curiae? Then how his vital role in the criminal trial? And what are those judgments related to amicus curiae? So these are the frequently asked questions in professional ethics. Therefore, we have chosen this topic for today. Now I am going to address this topic under 4 headings. What are they? First is, who is an amicus curiae? Number 2, what are the duties and responsibilities? Number 3, what are the constitutional provisions that governs an amicus curiae or the legal representation? Number 4, what are the leading cases on amicus curiae? So now let us ask, who is an amicus curiae? It originates from a Latin term which means friend of court. Now let us ask ourselves, who is our friend? One who is helping us, one who is guiding us, and one who is setting the correct path for us. He is a good companion and he is a good friend. So if we want to be a friend of the court, so friend of the court, what he has to do is, hello, please come. Friend of the court is, he has to put forth all the facts and circumstances before the court, complete disclosure. Number 2, what are the legal provisions involving the questions? And then he has to interpret in such a way that he is not biased to any party, but he is assisting the court. But for what purpose? To arrive at justice, to uphold the majesty of law and justice. That is most important. So that is the role of friend of a court, that is amicus curiae. Now, what are his responsibilities and duties? Responsibilities and duties, as I've said, he should always disclose everything in entirely. And how is he being appointed? Amicus curiae comes to the picture under what circumstances? There are 2 purposes or 2 reasons under which amicus curiae is appointed. The first reason is when the clients are duly represented by their advocates, respective advocates, through filing Vakalatnama, everything, the parties are duly represented. But still, the Honorable Court might feel that we need to hear the expert in a particular field, maybe a cyber law, maybe a NDPS Act. So they wanted to hear a senior advocate who is expert in that particular field of law. Therefore, Amicus Curiae is appointed. He will not represent both the parties, but being a friend of the court, he will study or he will address only on the question of law, and then he will assist the court in a broader perspective. So this is one way where an Amicus Curiae is appointed, though they are duly represented by the advocate's consent. Number two, the second circumstance under which an Amicus Curiae is appointed, that is when an accused engages a counsel and then counsel does not appear, then court will appoint an Amicus Curiae to represent a party, to represent an accused. So this is then, that means he has to take care of the interest of the accused, to defend his right. Reason is the criminal jurisprudence. What does it say? Everyone, the law presumes that everyone is innocent unless and until it is proved beyond reasonable doubt. So therefore, he may be a terrorist, but when he has to brought under the crime, under criminal law, the protection is guaranteed under Article 21. So right to life and personal liberty is guaranteed under Article 21 to everyone, to all the persons. So what are the constitutional provisions that governs the legal representation or that governs the justice? First and foremost is our preamble is itself says justice, social, economic and political. Now moving on to Article 21, we all know that Article 32 is a heart and soul of the Indian Constitution. But when we read one of the judgments where Honorable Supreme Court has held that Article 21 is a heart and soul of the fundamental rights. So Article 21, what does it say? No person shall be deprived of his life or personal liberty except according to the procedure established by law. So what is that procedure? Procedure has to be fair, reasonable and just. This is very, very important. Number two is Article 22 Clause 1. It is right against arrest and preventive detention. Where a person is detained, he cannot be detained without giving him the reasons for the arrest. And we have to provide that he has the right to, fundamental right to consult the lawyers. And he has to be defended by the legal representatives. That is one of the fundamental rights under 22 Clause 1 of the Constitution of India. Now moving on to Article 39 capital A of the Constitution of India. What does it say? Provide free legal aid. To whom? To those who are underprivileged. If they are economically backward or any other disabilities, they should not be deprived of legal representation. Therefore, Supreme Court Legal Services Committee is there. When the underprivileged people, when they approach Supreme Court Legal Services Committee, they will appoint their panel lawyer at free of cost, because the clients will not bear any cost. It is free for them, but lawyers are being paid by the Supreme Court Legal Services Committee. By virtue of 39 capital A, this act was born, dear friends. That is Legal Services Authorities Act 1987. What is the purpose? Purpose is to provide free legal aid. Honorable Justice Muralidhar, now he is senior advocate in Supreme Court of India, he has always said it is free legal aid to the poor and it should not be poor legal aid. So we should always see to that he is well represented, well defended by the counsels. So now we have seen the provisions starting from the preamble, Article 21, Article 22 Clause 1, Article 39 capital A, Legal Services Authorities Act, which says that everyone, more particularly in the criminal trial, an accused has to be represented by a counsel. Right? Now, how this has been interpreted by the Honorable Supreme Court. Let me give you two citations, dear friends, one by one. I will narrate the facts also, and they have said what are the guidelines to be followed in the trial court. The first citation is AAR 2020 Supreme Court 232. I repeat, dear friends, AAR 2020 Supreme Court 232. Anoki Lal, the name of the case is Anoki Lal versus State of Madhya Pradesh. This matter came up before the three judges bench. Honorable Justice Uday Umesh Lalit, Honorable Justice Miss Indu Malhotra, and Honorable Justice Krishna Murari. So let me tell you about the facts of the case. Quite interesting. Dear friends, the facts of the goes like this. Here the trial court has punished for the offence under section 302 IPC and imposed death sentence. Generally, the trial court cannot grant award death sentence unless and until it seeks a confirmation from the High Court. So they sought a confirmation from the High Court and then imposed death sentence. He prefers an appeal to the High Court. High Court also has confirmed the death sentence imposed on this person. Now he prefers an appeal before the Supreme Court. The question before the Supreme Court, the Honorable Supreme Court has appointed Mr. Senior Advocate Siddharth Luthra as an amicus curiae in this case. So what was the points that he put forth before the Honorable Court is this. The Senior Advocate has said, my lords, that when the framing of charge, at the stage of framing of charge against an accused, an amicus curiae was appointed on 19th February 2013. On the very same day of his appointment, he was asked to defend the accused. How is it possible? When you appoint an amicus curiae today and you ask him to defend the accused at the time of framing of the charge, when did he had time to go through the papers? Where was the ample opportunity given? Whether did that amicus curiae consulted the accused? Whether did he had grip over the matter? Nothing. But simply they have appointed amicus curiae and then they have asked him to defend the accused. So it is just like fulfilling the procedure without realizing its importance. Thereafter what happened? Nearly 13 witnesses were examined within 7 days. And within 2 weeks, the trial was over. So therefore, the Honorable Supreme Court has always held a right to speedy trial is one of the fundamental rights guaranteed under Article 21. But at the same time, when you are hurrying, justice should not be buried. What about the other side? Look at the other side, who is an accused of for the murder charges, but he is not being defended properly by amicus curiae. Time was not given. Ultimately, death sentence was imposed. It is not 7 years or 5 years, death sentence. Once you want to take away the life of a person, where is the ample opportunity? Where is the question of fairness, reasonableness and just? So that is all missing. So therefore, these were the points put forth by the Senior Advocate before the Honorable Court. So the Honorable Court considered what is the importance of amicus curiae in criminal trial, as well as what are the sequences, what are the consequences. Therefore, the Honorable Supreme Court has held that we are going to pass certain guidelines. What are those guidelines? An advocate, when you are appointing an amicus curiae for an accused, he should get the ample opportunity. What is that ample opportunity or the sufficient time? It is minimum 7 days, but it depends upon it may vary from the case to case. Number one. So when you are going to appoint an amicus curiae, what is his standing at the bar? So he must have at least 10 years experience as an advocate practicing in the criminal trial. So like advocate on record examination, who is supposed to give you a certificate or training, an advocate on record must have a standing for 10 years. Similarly, for an amicus curiae also 10 years. When a matter is before the Honorable High Court and there is a possibility of convicting him for death sentence, then senior advocate must be preferred by the Honorable High Court. So these are the guidelines, dear friends. I would like to read few lines from the judgment. See, when these appeals came up for final hearing, certain issues were highlighted by Mr. Siddharth Luthra, learned senior advocate, who appeared for the accused on behalf of the Supreme Court Legal Services Authority. Now, what are the principles and guidelines? See, the following principles therefore emerge from the decisions referred to here and above. The Honorable Supreme Court has discussed many cases and they have culled out the principles. So, what are the principles? Number one, Article 39 capital A, inserted by the 42nd Amendment only to provide free legal aid. Number two, it should be reasonable, fair and just procedure to be followed, because which is guaranteed under Article 21. And they have also said about 39 capital A of the Constitution. And then finally, they have culled out certain norms so that the infirmities that we have noticed in the present matter are not repeated. So what are those norms? Firstly, in all cases where there is a possibility of life sentence or death sentence, learned advocates who have put in minimum of 10 years practice at the bar alone be considered to be appointed as amicus curiae or through legal services to represent an accused. Second, in all matters dealt with by the High Court concerning confirmation of death sentence, senior advocates of the court must first be considered to be appointed as an amicus curiae. Then, whenever any learned counsel is appointed as amicus curiae, some reasonable time may be provided to enable the counsel to prepare the matter. There cannot be any hard and fast rule in that behalf. However, a minimum of 7 days time may normally be considered to be appropriate and adequate. So like this, norms were laid down by the Honorable Supreme Court. There is yet another case, dear friends. This is very, very important. With this, I will conclude my lecture. So it is reported in 2011, volume 4 SEC, page number 729. Muhammad Sukur Ali versus State of Assam. The matter came up before Honorable Justice Markandeya Kadju and Honorable Justice Gyan Sudha Mishra. I request each one of you to read this judgment. It is wonderfully written judgment, though it is captioned under order, but they have beautifully discussed what is American law, how lawyers are represented even 3 centuries before in England, and they have discussed about Rowlatt Act. Everything was beautifully discussed. So what was the question involved in this case? The important question is this: when a counsel for an accused did not appear before the High Court, what is the effect? When a counsel failed to appear on behalf of the accused before the High Court when the matter was called out, whether Honorable High Court should go ahead with the matter and pronounce the judgment, or in the absence of an accused appearing on behalf of the accused, then do they appoint an amicus curiae? That is the important question that came up for consideration. Here what had happened, the client, the accused, had appointed one advocate called Chaudhary. Thereafter, subsequently, he obtained NOC from Mr. Chaudhary and he appointed Mr. Sinha. When the matter came up, in the cost list, they had shown Chaudhary who had already given NOC, but Sinha's name did not appear. So Mr. Sinha could not understand that his case was listed. So there was a bona fide mistake. So matter came up before the Honorable High Court. High Court felt that none appeared on behalf of the accused. So therefore they have passed a judgment. without appointing an amicus curiae to defend the interest of the accused. So matter came up before the Honorable Supreme Court. Honorable Supreme Court has appointed Mr. Fali S. Nariman, Senior Advocate. So in that case, Senior Advocate presented his case before the Honorable Supreme Court. In a criminal trial, the consequences, the very, very severe, because you are taking away somebody's right. So therefore, when somebody is not appearing for any reasons, intentionally, deliberately, or by mistake, he did not appear also, it is a duty that a court should see to that interest of the accused is taken care by appointing an amicus curiae, by giving him ample opportunity to prepare the case. Thereafter only the matter should be heard and judgment should be passed. Right? Therefore, reinforcing or reiterating that Article 21 is the heart and soul of the fundamental rights, and that should not be taken away lightly. So the Honorable Supreme Court has considered all these issues, and they have remanded the matter back to the High Court for fresh disposal, but not before the same judge, but before the different bench who had not decided the earlier case. So this was the judgment, dear friends. So with this, I conclude, and it is really an honor to deliver a presentation on amicus curiae. Thank you so much. Thank you.